Well, hello everybody. I'm Hazel Genn. I can't see you, but I'm hoping that you can see me. And I've come along today to give a small lecture on the impact of the Human Rights Act 1998 on precedent and statutory interpretation. The material in the lecture draws on material from chapters, I think probably 1, 2, 3 and 5 of the study guide. So what I'm trying to do, instead of dealing with it in the way that it's dealt with in the study guide, is to draw it together so that you have a sense of what the key issues are. And the reason that I chose this today was because these issues about the impact of human rights on statutory interpretation and on precedent are actually very topical at the moment. Lots of people are talking about it, and you may or may not have seen that the Conservative government have recently issued a paper setting out the changes that they would want to make to the Human Rights Act 1998 in light of their views of the way that the United Kingdom courts, or the United Kingdom Supreme Court, has been relating to the jurisprudence of the European Court of Human Rights in Strasbourg, and also how they have been interpreting some of the provisions of the Human Rights Act. So this is a topical subject, and what I want to do is to go through the issues and try and focus on some of the key issues and the differing views. So this outline shows you where I'm going with this lecture. We're going to start with a very quick background to the European Convention on Human Rights. I'm assuming that you're all familiar with it, but I'll just remind you of what the key issues are in that. We'll look at some of the relevant provisions of the Human Rights Act 1998 and think about the approach of the UK Supreme Court to the jurisprudence of the European Court of Human Rights. Then move from issues to do with precedent, the relationship between the UK Supreme Court and the European Court of Human Rights, and then move on to the way in which the UK Supreme Court has interpreted UK domestic legislation that engages convention rights. And then I want to look fairly briefly at the Conservative government proposals for changes to the Human Rights Act 1998, and to look at some of the views of the senior judiciary, because this is a topic, as I said, which is topical, but on which there are quite different opinions, not just between the government and the judiciary, but also within the judiciary themselves. There are differences of view, there are different nuances, different senses about what the relationship between the UK courts and the Strasbourg court should be. So that's the outline, that's where we're going. First of all, background to the European Convention on Human Rights. As you will all know, this is an international treaty drafted in 1950. It was a treaty that was signed following the Second World War. The idea of the treaty was that if you could get states of Europe to come together to agree to respect and protect fundamental rights and freedoms, that might help to avoid the kind of horrors that took place during the Second World War. So the idea of this European Convention on Human Rights was to get many states to come together to agree that they would protect fundamental rights and freedoms. I've listed out some of the key rights and freedoms there on the slide. It's not comprehensive, but it's many of the key rights. So the right to life, prohibition against torture, prohibition against slavery, forced labour, etc. Each of these rights was contained within an article of the European Convention on Human Rights, and that's where they're still referred to as by their article number. So the right to life, Article 2. Prohibition against torture, Article 3. No punishment without law, Article 7. Prohibition of discrimination, Article 14. So these give positive rights to, it gives a positive right to protection from government interference, state interference with these rights and freedoms. Now, it's important to remember, for the point of view of the discussion that we're having today, is that not all of the rights and freedoms contained within the European Convention on Human Rights not all rights and freedoms are seen in the same way. So some of them are seen as absolute rights and which are inalienable, can't be interfered with by the state. Others of the rights are described as being contingent. That means that there can be some interference with those rights. We use the term derogation, which describes the fact that a state can opt out of a right in particular circumstances, or that they can, to some extent, interfere with a right if there's a good justification for it. So the absolute rights are Articles 2, 3, 4 and 7. I'll just go back so you can have a look at those again. So the right to life, prohibition of torture, prohibition against slavery, no punishment without law, and prohibition against discrimination. Those are all those are inalienable rights, absolute rights that can't be interfered with. But things like the right to liberty and security, the right to a fair trial, respect for family life, freedom of thought, conscience and religion, freedom of expression, assembly and association, those are rights that can, in certain circumstances, be interfered with if there is a justification for the state, by the state. So there can be derogation from those rights insofar as a state can justify the need, and we're going to talk about that now. How does a state justify the need to interfere with one of these fundamental rights and freedoms? Well, a public authority, so an authority, an agency of the state, can do something that affects a human right if they can demonstrate that they meet certain criteria. And so the criteria that they have to meet are, first of all, that any interference with the right is appropriate in order to achieve whatever the objective is. So why is it that you need to interfere with this right? Is it appropriate? Is the interference that you're proposing appropriate to achieve that particular objective? So, for example, if you say, I need to interfere with the right to liberty in order to secure the greater right or the broader right to national security, and that is a reasonable objective, if you have to do that, is the interference with the right that you are proposing appropriate to achieve that objective? So that's one of the things that a state must comply with. Secondly, the interference has to be necessary in the sense that there's nothing less that you could do, no less severe way of achieving that objective. So what you're proposing to do is appropriate, but it's also necessary. You need to do that thing in order to achieve the objective. And then thirdly, the state has to establish that what they're proposing to do is reasonable in the circumstances, reasonable in all of the circumstances. So the principle of proportionality requires that any interference with one of the Convention rights should be necessary and should go no further than what is essential to achieve the objective. That's the formulation, that's the concept of proportionality, that what you are the interference that you are proposing is necessary and proportionate to the objective that you are trying to achieve. And of course it's for the courts to decide whether or not the justification, the grounds for derogation, meet the requirement of proportionality. The court that has the final word, or has had the final word up until 1998, the court that had the final word on issues to do with human rights and potential infringements of the European Convention on Human Rights, is the European Court of Human Rights in Strasbourg. This is an international court based in Strasbourg in France, and the court hears cases where there is an allegation that there's been a breach of the European Convention on Human Rights. Procedure of that court, which you don't need to know in detail, but it's worth knowing so that you understand the terminology of the discussions of cases in the European Court of Human Rights, is that first of all there is a preliminary scrutiny by 3 judges who decide whether or not there's a case to be dealt with, and then you will normally have a decision of a chamber of the European Court of Human Rights by 7 judges. But where a case is dealing with an important point of law, it may be heard by what's known as a grand chamber of 17 judges. And the reason I stress this is because there's some of the cases that we're going to look at are dealing with decisions heard by the Grand Chamber. So the European Court of Human Rights has the responsibility for developing jurisprudence on human rights. Up until 1998, if somebody in the United Kingdom believed that there had been a breach of their human rights, if they wanted to pursue a remedy for that breach of human rights, they would have to take the case to the European Court of Human Rights in Strasbourg. So it was a rather long-winded process in order to enforce or to prevent an infringement of human rights. In 1998, the Labour government, the Labour government that had been elected in 1997, so the UK Labour government elected in 1997, passed the Human Rights Act 1998. What the Human Rights Act 1998 did was to incorporate into UK domestic law the protections provided under the European Convention on Human Rights. So the practical effect of that is that a citizen of the United Kingdom who believed that their human rights were being infringed could bring an action in the English courts. They didn't have to go. They weren't required to go to the European Court of Human Rights. So they could bring an action in the English courts. But for our purposes, what we're interested in today is what has happened since the passing of the Human Rights Act 1998 in relation to the respective roles of the English courts and the European Court of Human Rights in Strasbourg. So since the passing of the Human Rights Act 1998, a citizen in the UK who believes that their human rights have been infringed can bring an action within the English courts. And the question is, how do the courts deal with those cases? How do they interpret the meaning of convention rights? How are convention rights interpreted and applied in the UK courts? And how has the relationship between the UK courts, and in particular the House of Lords, which then became the UK Supreme Court, how has the relationship between our final Court of Appeal developed with the European Court of Human Rights in Strasbourg? So in order to look at that relationship, to think about how that relationship has developed, we need to focus on the terms of the Human Rights Act 1998, which set out what that relationship was supposed to be. So remember, when we're focusing on the Human Rights Act 1998, this is UK domestic legislation that has incorporated into our law the European Convention on Human Rights. I should also say, by way of an aside, that you need to remember that although the Human Rights Act 1998 was passed in the UK, although it was passed in 1998, it didn't come into effect until 2000, and that was to give an opportunity for all of the English judiciary to be trained in human rights law, because they didn't all necessarily have a background in human rights law. So although we talk about the Human Rights Act 1998, it didn't actually come into effect until 2000. Anyway, under the Human Rights Act 1998, Section 2.1 provides that a court or tribunal determining a question which has arisen in connection with a convention right must take into account any judgment, decision, declaration or advisory opinion of the European Court of Human Rights, etc., etc. They must do this whenever it has been made or given, so far as, in the opinion of the court or tribunal, it is relevant to the proceedings in which that question has arisen. I'll leave you to read that for yourselves later on. What does this mean? Section 2.1 of the Human Rights Act 1998 gives a direction to England and Wales and the courts in England and Wales and the UK Supreme Court that a court or tribunal, actually it's not just courts in England and Wales, it's courts in the United Kingdom, gives a direction that any court or tribunal in the United Kingdom determining a question that's arisen in connection with a human right must take into account any judgment, decision, declaration or advisory opinion of the European Court of Human Rights. And what we're going to focus on in terms of the relationship between the UK courts and the European Court of Human Rights in Strasbourg in terms of precedent, how precedent operates. The critical section is section 2.1 and how the UK courts have interpreted that. So section 2.1 tells us what the relationship is between the UK courts and the European Court of Human Rights in terms of the influence of the jurisprudence of the European Court of Human Rights on the UK courts. And what the UK courts have to do in deciding convention issues is to take into account the jurisprudence of the European Court of Human Rights. The next sections that affect the relationship between UK law and the European Convention on Human Rights, and affects the relationship to some extent between the UK courts and the European Court of Human Rights in Strasbourg, is to do with statutory interpretation. And section 3 and section 4 of the Human Rights Act 1998 set out what the UK courts have to do in relation to statutory interpretation. So section 3.1 tells us that so far as it is possible to do so, legislation must be read and given effect in a way that is compatible with convention rights. So as far as it's possible to do so, UK domestic legislation has to be read and given effect in a way that's compatible with convention rights. Section 4.2 tells us that if the court is satisfied that the provision is incompatible with a convention right, it may make what's called a declaration of that incompatibility. A declaration of incompatibility is considered a last resort, and as I'll say later on, a declaration of incompatibility by a UK court does not affect the validity or continuing enforcement of a piece of UK domestic legislation, but what it does is to put pressure on the government to take remedial action, because if the UK courts have said that UK domestic legislation is inconsistent with convention rights, then essentially they're saying that the government is trying to do something which interferes with convention rights, and that puts pressure on them to think about whether and what remedial action they might take. So I'm going to come back to the statutory interpretation issue later on and deal immediately with precedent. But just to summarise where we've got to now, in 1998, the European Convention on Human Rights is incorporated into UK domestic law, which means that UK citizens can enforce their convention rights through the UK courts. The Human Rights Act itself sets out the relationship between the UK courts and the European Court. And it says that as far as the doctrine of precedent is concerned, the UK courts are required to take into account the jurisprudence of the European Court of Human Rights in Strasbourg. As far as statutory interpretation is concerned, the Human Rights Act tells us that the UK courts must, insofar as it is possible, read and give effect to domestic legislation in a way that is compatible with convention rights, and if they can't do that, then they may make a declaration of that incompatibility. So let's move on to the question of how the UK courts, and particularly how the UK Supreme Court, has interpreted the responsibility to take into account the jurisprudence of the European Court of Human Rights. How have they gone about doing that? What has been the approach of the courts? Well, one of the leading cases, and all of these cases are mentioned in the subject guide, so I do urge you to have a look at these cases. One of the leading cases on this issue is the case of Alconbury in 2003. This was a case that concerned whether or not the arrangements for planning appeals complied with the provisions of Article 6. It isn't necessary to know the detail of that case for the moment. The key thing that we're focusing on is that in the discussion of the extent to which UK legislation was or was not, the extent to which the UK court should follow the jurisprudence of the European Court of Human Rights. The weight of opinion in the court is summed up by the quote that I've got on this slide from Lord Slynn. And this is an important statement for providing the lead to the courts in cases following. You see that the Alconbury case was finally decided. It was a House of Lords case in 2003 because, of course, the UK Supreme Court wasn't established until October 2009. And so up until 2009, the final Court of Appeal in the UK was the House of Lords. So in the Alconbury case, Lord Slynn was thinking about the extent to which the UK courts had to follow the jurisprudence of the European Court of Human Rights. And he said, although the Human Rights Act 1998 does not provide that a national court is bound by these decisions, it is obliged to take account of them so far as they are relevant. Now, this next bit is important. He says, in the absence of some special circumstances, it seems to me that the court should follow any clear and constant jurisprudence of the European Court of Human Rights. So, given that the Human Rights Act didn't come into effect until 2000, what we have is a very clear statement by the House of Lords Final Court of Appeal in 2003 that says that although the national courts are not bound by decisions, we're using here the language of precedent. Are precedents binding precedents? Are they persuasive precedents? Is the jurisprudence of the European Court of Human Rights binding, or is it merely persuasive? So what Lord Slynn is telling us is that national courts aren't bound by decisions in the way that we understand the principle of stare decisis, but they are, but in the absence of some special circumstances, in his view, the court should follow any clear and constant jurisprudence of the European Court of Human Rights. So he's saying that there has to be some reason, some good reason for not following the decisions of the European Court of Human Rights. So that was Alconbury in 2003. That case was followed in 2004 by another decision of the House of Lords in the case of Ullah. This was a case involving deportation of somebody from Pakistan, question about whether they could be returned to their own country, and if they were returned, whether or not they might be subject to torture. Again, the details of the case are not that important. What's important is the approach taken by the House of Lords on the question of precedent. And here, Lord Bingham, who at the time was the senior law lord in the House of Lords, he said no national court should, without strong reason, dilute or weaken the effect of the Strasbourg case law. He says it is of course open to member states to provide for rights more generous than those guaranteed by the Convention, but such provision should not be the product of interpretation of the Convention by national courts, since the meaning of the Convention should be uniform through the states party to it. So stressing the need for uniformity in interpretation of the meaning of Convention rights. And then this next sentence is very important. He says the duty of national courts, so courts who are signatories to the European Convention on Human Rights, the duty of national courts is to keep pace with the Strasbourg jurisprudence as it evolves over time. No more, but certainly no less. So I think that the certainly no less is a very important emphasis there. So our duty as national courts, so in the UK, the duty of the House of Lords is to keep pace with Strasbourg jurisprudence. It doesn't need to do more than Strasbourg is doing, but it certainly shouldn't do less. So that's the case of Ullah. So clear signals coming that the senior judiciary in the House of Lords, the most senior, most distinguished judiciary in the House of Lords, are taking the view that actually the UK, in deciding cases brought to the courts by citizens of the UK, should be following the jurisprudence of the European Court of Human Rights in Strasbourg, unless there's a very good reason not to. Slightly different tack in the case of Horncastle in 2009. Now this is after the UK Supreme Court had been established in October 2009. And this is a case where the UK Supreme Court actually refused to follow a decision of the European Court of Human Rights in the Al-Khawaja case. The Al-Khawaja case concerned whether or not you could convict a defendant in criminal justice proceedings on the basis of hearsay evidence alone, and if one were to do that, whether that would be a breach of Article 6 of the right to a fair trial. The decision in Al-Khawaja was that conviction on hearsay evidence was a breach of Article 6. This went very much against the principles of evidence in the UK. And Lord Phillips, who gave the lead judgment in Horncastle, who was at the time the President of the Supreme Court, Lord Phillips was the first President of the UK Supreme Court, and he said that a domestic court would normally apply principles established by the European Court of Human Rights, but that there will be rare occasions where the domestic court has concerns as to whether a decision of the Strasbourg Court sufficiently appreciates or accommodates particular aspects of our domestic process. In these circumstances, it's open to the domestic court to decline to follow the Strasbourg decision, given reasons for adopting this court. So he's saying that if you get a decision from the European Court of Human Rights that simply doesn't appreciate aspects of our domestic process, then it should be open to us to decline to follow that decision. And what's interesting about the Horncastle case is that it throws up, or it's an illustration of sometimes the tension that there is between the European Court of Human Rights, which is a court in a civil law jurisdiction, a civilian jurisdiction that has inquisitorial procedures, as compared with the UK courts, the UK common law system, which uses adversarial procedures both in criminal and civil proceedings. And the fact that there's this sense that actually people who come from civilian tradition don't necessarily fully appreciate or understand some of the principles of adversarial procedure. And I think the Horncastle case is an example where the UK Supreme Court thought, well, actually, this decision, the Al-Khawaja decision, doesn't sit well with our well-established adversarial principles, and we shouldn't follow it. Interestingly, that case was followed by another case, Manchester County Council and Pinnock, in 2010, which was where the lead judgment was given by Lord Neuberger, who is now the current President of the UK Supreme Court, where again you're getting this a slight difference, where he says the court is not bound to follow every decision of the European Court. It would be impractical to do so, sometimes it would be inappropriate. But then he says, of course, we should usually follow a clear and constant line of decisions by the European Court, and he refers to the Uller case, but we are not actually bound to do so, or in theory at least, to follow a decision of the Grand Chamber. So this is saying we're not bound to follow every decision. We would normally follow a clear and constant line, but we're not actually bound to do so. So another case which suggests that that we shouldn't always be slavishly following the decisions of the European Court of Human Rights. Weighing into this debate about the extent to which we do or we don't follow the jurisprudence, in December 2011, Lord Irvine of Lairg, he was the Lord Chancellor who was responsible for the passing of the Human Rights Act 1998. He was the Labour Lord Chancellor, and he took special responsibility for seeing the Human Rights Act through the legislative process. He gave a speech in London in December 2011, indeed the day before a further decision in the Al-Khawaja case, where he addressed himself specifically to the questions of the interpretation of convention rights. And he said, while there are variations of approach between different cases and judges, the domestic courts, the UK courts, have strayed considerably from giving effect to Parliament's intention as expressed in Section 2. They've done so by proceeding on the false premise that they are bound or as good as bound to follow any clear decision of the European Court of Human Rights, which is relevant to a case before them. So this is Lord Irvine criticising the courts for too closely following the jurisprudence of the European Court of Human Rights. And I think this next extract is quite interesting. He goes on to say, having to take something into account is a common experience in many different contexts. It can be paraphrased as having regard to, consider, treat as relevant, or bear in mind. He says the starting point is the language. Take account of is not the same as follow, give effect to, or be bound by. He says Parliament, if it had wished, could have used any of these formulations. It did not. The meaning of the provision is clear. The judges are not bound to follow the Strasbourg court. They must decide the case for themselves. So this is the former Lord Chancellor responsible for the implementation of the Human Rights Act 1998 saying, you know, hey guys, we thought about this when we passed the Act, when we drafted Section 2, we knew what we were doing and we used the words take into account. We didn't say bound by. We could have used those words if we wanted to. So we did this very deliberately. So in his view, the UK Supreme Court should certainly look at what's going on in Strasbourg, but shouldn't feel bound to follow those decisions. The next day, the day after the speech was given, the European Court of Human Rights gave its decision, having reconsidered the case of Al-Khawaja. They gave a decision where they made a concession to the UK Supreme Court, and they accepted that under certain circumstances hearsay evidence could be relied on, and that it was not inevitably a breach of Article 6. And the Horncastle and Al-Khawaja cases have been used as an argument for saying that actually there is a dialogue between the European Court of Human Rights and the domestic courts, and that where the domestic courts take a different view, so if they choose to take a different view, and they do take a different view and they feel strongly about it, that may in itself influence the European Court of Human Rights. So an example of a bit of dialogue. I'm going to come back to where we are on all of this at the end. So, but for the moment, to summarise that, there are different views among the judiciary about the extent to which the UK Supreme Court is or isn't bound by decisions of the European Court of Human Rights. What is said is that normally the court should normally follow the European Court of Human Rights. But there could be circumstances, there may be circumstances where they might not follow a clear line, but there would need to be very good reasons for it. So I think what we get from that is a sense that the Supreme Court feels that there have to be special reasons for not following the jurisprudence of the European Court of Human Rights. Whereas what Lord Irvine was saying was that the intention of Parliament in passing Section 2 was that you start from another way. You don't start with the assumption that you should follow them, but with if there are special reasons you don't follow them, but that in each case you basically, the UK courts take their own decision while looking at what's been going on in Strasbourg. It may be quite a small difference in emphasis, but there is a difference there. Moving on to interpretation and declarations of incompatibility. So the Human Rights Act 1998, Section 3.1 says, so far as it's possible to do so, legislation must be read and given effect in a way that's compatible with convention rights. And Section 4.2 tells us that where it can't be done, so where legislation can't be read in a way that's compatible, then the court may make a declaration of incompatibility. What happens then? If we have a declaration of incompatibility, Section 3.2 tells us that a declaration of incompatibility does not affect the validity, continuing operation or enforcement of any incompatible primary legislation. And there is a very specific reason for that. It protects parliamentary sovereignty. We know from our understanding of our constitutional arrangements that Parliament is sovereign. Parliament can make or unmake any law, and that a valid act of Parliament, once it has been passed, cannot be invalidated or challenged. It can only be changed by Parliament itself. So this is important protection of that constitutional principle of parliamentary sovereignty. So a declaration of incompatibility is uncomfortable, and it will put pressure on the government to think about whether it needs to take remedial action, and in most cases government has taken remedial action, but it does not invalidate the Act unless and until Parliament amends the legislation. The Act remains in force and will be enforced. So the approach to the approach to interpreting convention rights by the English courts, you know that the main approaches to statutory interpretation adopted by the UK judiciary tends to be either a literal approach or a purposive approach, or sometimes the judges will adopt an approach where they modify the language in order to avoid some kind of absurdity. That used to be referred to as the golden rule, but I think we've sort of done away with the terminology of rules and we think about literal approaches and purposive approaches. But in relation to the interpretation of convention rights, the judiciary have applied other interpretive devices, and these are the concepts of reading down, reading in and reading out. And again, these are terms that you need to know in order to understand what the judges are doing in seeking to interpret domestic legislation in a way that is consistent. So reading down, where a judge says that they are reading down the words in a statute, they're limiting the meaning of words in order to achieve a compatible outcome. So they look at the words and give a very, very restrictive interpretation in order to be compatible with convention rights. Reading in allows a judge to introduce words or meanings to ensure compatibility, and reading out allows the court to remove or refuse to enforce provisions that would otherwise make the legislation incompatible. So you can see that through these interpretive devices, the judges have considerable power to, in a sense, interfere with the language that Parliament has used in the statute. And so we're moving a long way from strict literal interpretations. And I think it's probably fair to say that the way that the courts have interpreted Section 3 of the Human Rights Act, the requirement to the requirement to interpret legislation in a way, insofar as it's possible, to give effect to convention rights. In a way that's compatible with convention rights. The power that they have under Section 3 is a power that they've used to really strain the wording or strain the interpretation of wording that's been used. I think one of the clearest cases, one of the clearest examples of this and clearest explanations of of how Section 3 can be used is the case of the Crown and A, number 2, a case decided by the House of Lords in 2001. This concerned interpretation of Section 41 of the Youth Justice and Criminal Evidence Act 1999 that prohibits the admission of evidence of complainants' sexual behaviour. In this particular case, the defendant was arguing, the defendant who'd been convicted was arguing that his inability to bring evidence of the complainant's sexual behaviour interfered with his ability to mount an effective defence, and so was an infringement of Article 6 of the Human Rights Act. In the case, Lord Steyne, giving the leading judgment, talked about the obligation, the interpretive obligation under Section 3 of the 1998 Act, and he says that obligation is a strong one. Section 3 places a duty on the court to find a possible interpretation compatible with convention rights. He says that in complying with the requirement in Section 3, it will sometimes be necessary to adopt an interpretation which linguistically may appear strained. the techniques to be used will not only involve the reading down of express language, so limiting the meaning of express language in a statute, but also the implication of provision. So imagining that Parliament had actually said something which they haven't said. He says a declaration of incompatibility is a measure of last resort. It must be avoided unless it is plainly impossible to do so. So in this extract from the case, what we hear is that Section 3 of the Human Rights Act gives the judges considerable scope to read in, read out, read down words, provisions in the words into the provisions of the statute, and that that judges should seek to do this as far as they possibly can, because a declaration of incompatibility is absolutely a last resort. It must be avoided unless it is plainly impossible to do so. So that's Lord Steyn in the case of A. Another very good case, worth reading because of the explanation about statutory interpretation, is the case of Genn and Mendoza, decided also by the House of Lords in 2004. This involved a gay couple and questions about whether or not a gay couple living as a heterosexual couple, so living as if they were husband and wife, whether or not they could take the benefit of succession rights under the Rent Act 1977. And it was held that it was possible to read down the 1977 Rent Act so that it was compliant with the rights in the Convention. Court had to depart from a previous interpretation given by the Court of Appeal, given by the House of Lords in Fitzpatrick and Sterling Housing Association. They were saying that the way that the provision was drafted was discriminatory. It was discriminating against people who were not heterosexual, and therefore it should be construed in a way that was compliant, because of course discrimination is absolutely prohibited under the Human Rights Act. So that's Genn and Mendoza. Other cases that have looked at declarations of incompatibility, one of the most famous cases, case of prisoners' voting rights, highly controversial, very topical, and case that has caused great unhappiness to the Prime Minister David Cameron. Basically the rule in the United Kingdom, the law in the United Kingdom under Section 3 of the Representation of the People Act 1983, as amended, provides that any prisoner, any person serving a term of imprisonment, cannot vote in elections. In the case of Hurst in the UK in 2005, the European Court of Human Rights ruled that that section was incompatible with Article 3 of Protocol number 1 of the European Convention on Human Rights, that provides for free elections. In the case of Smith and Scott in 2007, which was a Scottish case, the courts in Scotland issued a declaration of incompatibility. They said it was impossible, they would not, and that it was impossible to read down the words of Section 3 so that it was compatible with the European Convention on Human Rights. And so it was held that that Section 3 of the Representation of the People Act 1983, as amended, is incompatible with the European Convention on Human Rights. The European Court of Human Rights has directed the UK government to amend UK legislation. This has caused great unhappiness among the government. In 2013, in the case of Chester, the UK Supreme Court again was faced with the issue of whether or not the UK ban on prisoner voting was an infringement of human rights, and the Supreme Court, they had been invited to make a further declaration of incompatibility. They said there was no point in making another declaration of incompatibility. One had already been made. The government knew that the European Court of Human Rights had said that our law was incompatible with convention rights. But you can see from this side, Lord Mance and Lord Sumption both agreed that the Supreme Court ought to follow Convention jurisprudence on this, that the European Court had said that the UK ban on prisoners' vote, blanket ban on prisoners' voting rights, was an infringement of Convention rights, and both Lord Mance and Lord Sumption in the Chester case said that there has to be a very good reason for not following that clear line of authority. Another case where there was a declaration of incompatibility, case that's mentioned in the subject guide, the Belmarsh case, where the House of Lords held that Section 21 of the Anti-Terrorism Crime and Security Act 2001 was incompatible with human rights because people were being detained without charge. I'm rushing now because I feel as though because I'm getting close to the end of my time, and I want to get to the end of the lecture and to make the final points. Case of Bellinger and Bellinger is another case that involved a declaration of incompatibility. So I want to get on now with government responses to declarations of incompatibility and why the current government is upset about both the interpretation of statutes under the Human Rights Act and how precedent seems to be operating under the Human Rights Act. So where there is a declaration of incompatibility, although there's no legal obligation on the government to take remedial action, it creates pressure on them to do so. And in fact, in most cases where a declaration of incompatibility has been issued, the government has taken remedial action. And I've given you a website reference there to a document which gives a very interesting and quite detailed account of how the government has responded to declarations of incompatibility. But in October 2014, I think as a result of kind of a head of steam building up within certain bits of government, not all bits of government, certain bits of government, the Conservatives issued a paper setting out their proposals, or setting out what they proposed to do if they were returned to power after the general election that will take place in May 2015. They criticised the way the Human Rights Act 1998 had operated. They say that the European Court of Human Rights has developed mission creep. What they mean by that is that the European Court of Human Rights has been expanding the scope of Convention rights through its jurisprudence, through the development of its jurisprudence. There has been an extension of rights beyond what was anticipated in the original Convention. The government argues that the Human Rights Act undermines the role of the UK courts in deciding human rights issues in this country, and that it undermines the sovereignty of Parliament and democratic accountability. And they say that the Human Rights Act goes far beyond UK's obligations under the Convention. So the government is not happy about the way, or if you take what they say at face value, they're not happy about the way that the Human Rights Act has been interpreted and implemented by the UK courts. What they're saying that they're going to do, they say that in future Britain's courts will no longer be required to take into account rulings from the court in Strasbourg. They say the UK courts, not Strasbourg, will have the final say in interpreting Convention rights as clarified by Parliament. When this document was published, it was criticised for being legally illiterate on the grounds that they had misunderstood what the relationship was between the UK courts and the Strasbourg court. But anyway, the Conservatives are saying that in future that if returned to power, they will change the law so that Britain's courts are no longer required to take into account rulings of the Strasbourg court. And they say that they will end the ability of the Strasbourg court to force the UK to change law. Every judgment that UK law is incompatible with the Convention will be treated as advisory and will introduce a new parliamentary procedure to consider the judgment. And they say it will only be binding in UK law if Parliament agrees that it should be enacted as such. So just going back to that slide, you can see that the Conservative proposals, I think, are to some extent misunderstanding the relationship, but taking issue with some of the decisions that have been made and some of the explanations for the decisions that have been made by the UK courts in relation to convention rights. The last couple of slides give some extracts from speeches from senior judiciary which demonstrate that judges in the UK Supreme Court themselves have slightly different views on the relationship between the UK courts. This quote here from Lord Sumption comes from a speech that he gave last November 2013. It's an interesting speech, it's worth reading. His argument is that the Strasbourg court, by developing convention rights, by expanding the scope of convention rights through its jurisprudence, is actually going beyond the proper role of a court. He says that it's judicial lawmaking, and that because the UK courts tend to follow the decisions of the European Court in Strasbourg, that leads to that leads to changes in English law or in UK law that are in a sense undemocratic. Another speech given by Lord Neuberger runs along the same sorts of lines, but there are also speeches from Lord Mance and Lord Dyson that take a slightly different approach, that suggests that actually there isn't, that there is more of a balance between the UK courts and the European Court of Human Rights in Strasbourg.